Hello, everybody. Hi, Ava. Ava, baby, you're the one. Come on. Hi, sunshine. Who's my pup? Oh, I forgot a light. One that I gotta charge after every stream. There. Oh. Hello, Jerry Matthew Boyd. Hello, Buzzy Bug. Hello, Nana Laura. Hello, Wire Mother. One more. I love you. Dag nabbit. Oh, please. Hello, Eileen and Carlin. There's Earl coming back to open the doors again. Hello, Dark Zoomy. Hello, Jenny Green. He's going to do it too. Hello, Floor Lover. Hello, Linda Adams. Hello, Mortimer Duke. Hello, Donald Westerdale. Hello, Tail Smiles the Fox. Good to see you. Hello, Purple Kiv. Hello, Charlie. Hi, Ava, honey. What's up? Well, come on up. Yep. If you're going to be nose nudging me, you're going to be up here where everyone can see. Who's a good girl? Huh? Oh, the big yawns. Hey, quit it. You got your treats. Oh, and the cats know it's time for theirs. Oh, you guys are hilarious. Oh, I gotta put the cat cam on. Nobody wants to watch my butt. There we go. All right. In the There we go. That should satiate the beasts. Oh. Urban renewal. Gosh. Sorry, guys. It's my kid. Let me turn the volume down quick. There. Okay. It was no emergency. She was just sending me pictures of a drawing she did. So it's super cute. It's really neat and I love it. All right. Ava, you heard your mission. And she's on it. You can go back to collecting treats. I was just pointing out that, Charlie wanted to see your butt and you were complying. Oh no, honey. I am so sorry to hear that. That's awful. Thank God your neighbor could help you. My neighbor literally left me to die because he didn't think I was in trouble. It's okay, though. He didn't know. All right, tonight I've got a couple of short ones in Florida, and then Michigan, and then more Michigan, but a different part, and then back to Florida. So, oh no. I'm just glad you're okay, Purple Kiv.
Step on the H. Say your name for the judge, please. State your name.
My name is Sue Ellen Mims.
Who is this?
Sue Ellen Mims.
It's number 8.
You're before the court today for your first appearance. I'm going to appoint the Office of Public Defender to represent you. You've been charged with 1 count of battery on a person 65 years of age or older. That's a third-degree felony, punishable with 5 years in the Florida Department of Corrections and a $5,000 fine. 1 count of criminal mischief, over 200 but under 1,000. First-degree misdemeanor, punishable with 1 year in the county jail and a $1,000 fine. 1 count of petty theft, which is a second-degree misdemeanor, punishable with 60 days in the county jail and a $500 fine. I reviewed the probable cause affidavit. I found probable cause for your arrest. Ms. Mims, where do you live?
I was staying with her, sir. I didn't hit her. I noticed upon hearing. I did mess her window up. I did all that.
Is there
Is her address? Yes.
Is there-
1033.
Is there a prior record on Ms. Mims?
Trespassing 22, resisting without, prostitution. Well, she got older prostitution charge. I've seen calls, and an old aggravated assault in Georgia, and that's it.
All right. I am going to set a $5,000 bond on the battery.
But, Your Honor, she didn't hit her. She just busted the window and broke the stuff. She'll admit to that. Oh, golly, people don't understand the right to remain silent.
1,000 on the criminal mischief and 1,000 on the petty theft. You're to have no contact with the alleged victim in the case. Your next court date is July 9th at 9 o'clock. Good luck.
Did you say, sir?
July 9th.
July the 9th?
Yes.
Thank you.
Here you go, Miss Ma'am.
How much was that due for me to find out?
7,000.
Yeah.
Step on the X. State your name for the judge, please.
Number 7. Hold on just a second. All right, is this Ms. Dixon?
Yes, sir.
Ms. Dixon, you're before the court today for your first appearance. I'm going to appoint the Office of Public Defender to represent you. You've been charged with 1 count of possession of a weapon or ammunition by a convicted felon. That's a second-degree felony, punishable to 15 years in Florida Department of Corrections and a $10,000 fine. Possession of a illegal firearm, which I believe it would be a machine gun. Is that a second degree or a first, or is that a second degree or third degree? Mr. Phillips and Ms. Piazza?
Judge, I'm gonna need a second to look and see.
Okay.
This number
Well,
9,
Number 10.
number
It's
10.
possession
Okay.
of a machine gun or short barrel rifle.
It's a
Ms.
second
Dixon, I
degree,
was-
Judge.
Both are second degree, so those are both
Okay.
punishable to 15 years in Florida Department of Corrections and a $10,000 fine. I reviewed the probable cause affidavit. I'm gonna find probable cause for your arrest. Ms. Dixon, where do you live?
Atlanta, Georgia.
All right, and what are your, do you have any contacts with Bay County?
Yes, sir.
Are you working?
Yes, sir.
Pardon?
Yes, sir.
Where do you work?
Caregiver.
Where?
A caregiver. I just got a caregiver.
Okay. Is there a prior, what's the prior record on Ms. Dixon?
Georgia, she's got a battery and VOP in 24 and then 21 child abuse, DVSR, hindering harboring a fugitive. And that's it.
All right, I'm
Oh, she's a caregiver. That's her profession. And yet she's running around with machine guns and has a prior of child abuse on her record. How? How is she a caregiver? And to what?
gonna set a $25,000 bond on each case for a total of $50,000. You're to have no contact with the co-defendants or co-defendant. Your next court date is June 25th at 9 o'clock. Good luck.
Thank you.
Hold on 1 second. Next. Say your name.
Mr. McNichols, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been arrested on a violation of a municipal ordinance of panhandling. That's a misdemeanor, punishment to 60 days in the county jail. I've reviewed the probable cause affidavit. I find probable cause for your
Oh, panhandling. That's not too bad, right?
arrest. Sir, where do you live?
I'm a homeless person from on the floor.
Okay, is there a prior record on Mr. McNichols?
14 elsewhere in Florida, homicide, 12 armed robbery, 02 homicide, escape in 2000, 97 armed robbery ×2, ag assault and escape. And that's it.
All right, I'm gonna set a $1,500 bond based on his lack of contacts, his living condition, and his prior record.
And that is why when I see people holding up those signs asking for money, I don't stop. They may very well be in need. I don't stop.
His next court date is June 10th at 8:30. Good luck.
Can you step out for me?
Got a judge question.
Sir?
Judge, it says 17.2, the order got violated. Is it trying to verbally ask for money like student said, you spend $1, student not spend $1? Cause I ain't have a pan, a cup or a pot. I wasn't pilfering or nothing.
All right, that concludes the hearing, sir.
Can you step out, but next.
0743. Can I have appearances for the record, please?
Morning, Your Honor. Fawn Armstrong on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Darius Jones.
Okay, thank you. And Mr. Jones, thank you. I believe you already stated your name. So today is the date set for an arraignment in this matter. Before we get started, Attorney Akiriak and Rulli, did you want to address the plea?
Yes, Your Honor. We did not have an opportunity to review the report. I actually thought it was a CCW, but I just pulled it up now, so we need the court to read it to him.
All right, thank you. So this is a felony complaint charging that on or about June 5th of 2026 at Bedford Drive, that Mr. Jones did assault, batter, wound, resist, obstruct, oppose, or endanger Washtenaw County Sheriff Deputy Kevin Netto, a sheriff or deputy sheriff of the county of Washtenaw who the defendant knew or had reason to know was performing their duties. This is otherwise known as assaulting, resisting, or obstructing a police officer. Do you understand that charge against you?
They said I assaulted officer.
So I am just asking if you understand what you're being charged with at this point.
Yes.
Okay. So that is a felony with a maximum potential penalty of up to 2 years in jail, a $2,000 fine plus court costs, or both the jail time and the fine. Do you understand that potential penalty?
Yes, ma'am.
All right. Count 2 charges that you did attempt to commit the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof. That being to willfully and maliciously destroy or injure certain personal property, that being the Washtenaw County Sheriff Patrol Vehicle, a Chevy Tahoe, belonging to or possessed by the Washtenaw County Sheriff's Office. This is otherwise known as attempted malicious destruction of police property. Do you understand what you're being charged with there?
Yes, but
Okay, I'm not asking you if you agree with it at this point. I just want to know that you know what you're being charged with. Okay.
thank you.
That is a felony with a maximum potential penalty of up to 4 years in jail, a $5,000 fine plus court costs, or both. Do you understand that?
Yes, ma'am.
Thank you. So you do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, then don't worry about it.
By the way, guys, all of today's hearings are from today.
Do you have any questions about your rights?
Yes, ma'am. No.
Okay, thank you. All right, now because this is a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be June 18th, 2026. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases. The purpose is 2 things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So, do the attorneys want to address bond, please?
Yes, Your Honor. In this case, there was a report to 911 of several subjects fighting. This was at 1375 Concord Drive. There appeared to be 2 separate groups fighting each other. The group that defendant was alleged to have been in, it was alleged that several of them had weapons, had handguns, but they did not point them at anyone. They then left in a vehicle. The
Groups, two separate groups in Michigan. Ma'am, I think there's another word for that.
police were able to make contact with this vehicle on Bedford Drive. The defendant is alleged to have been in the back seat of that vehicle. There was a firearm loaded in the console, and then 2 other guns were found just when you pulled the back seat down, just back there. And then the defendant and then the 3 other males were detained. And this defendant then, when he was in the back of the patrol car, it was reported that he was repeatedly attempting to break out the window. He was kicking at the door panels. He was screaming at the officers and threatening them. And there's also in-car video displaying this. He attempted to get out of the vehicle. He put his leg in the vehicle door when they attempted to open the door to speak to him and tell him to stop doing what he was doing. But his behavior persisted.
It sounds like he needs a few more charges. They're lacking on what they are charging him with.
He appears doesn't have a criminal record. The person that was the driver of the vehicle was charged with the CCW offenses, and he is 21 years old. Mr. Jones is 19 years old. The 2 other males in the vehicle were 17 years old. I believe that they were released. But based on all of those factors and the concerns with the handguns, we are asking for a $20,000 cash bond. We are asking for a random drug and alcohol testing. I'm asking for a no-go to the address of the alleged fight, which was 1375 Concord Drive, Ypsilanti Township. I'm asking for a no contact with Erishawn Coles. That is a 15-year-old female. She is one of the witnesses that reported the fighting that occurred at that location. I'm also asking for no contact with the other perpetrators that were found in the vehicle. One is essentially a co-defendant, Dominique Jones, but also the 2 17-year-olds, Trayvon Jones Williams and Teardron Devontae Young, based on the allegations of the bad behavior between all of them and the potential for having weapons. Thank you.
All right.
I'll say something on behalf of the police car stuff.
Attorney Akiri Akinroli appears to have frozen. You should talk to your attorney. I can hear you. But as I stated earlier, anything that you say can be used against you in court. So hold up a second, please.
I'll try to send her a Teams message.
She just dropped off.
So I'm being charged with so-called assaulting a police officer or something like that.
It's the charge is assaulting, resisting, or obstructing.
I saw him in
No.
handcuffs.
Stop. Let your attorney speak for you.
Okay, sorry about that, Your Honor. My system went out. Darius, let me go ahead and talk with her, okay? I don't want you to speak about anything that happened because you have the right to remain silent. And anything that you say is going to absolutely be used against you, okay? Okay. Your Honor, we had an opportunity. We spoke with Mr. Jones on yesterday. I think the prosecutor says, the most important things. He does not have a criminal history. He's 19 years old. I don't, obviously have the report to even try and make sense of what had happened on that day.
Don't pretend like he had his 19th birthday and then started running around like a little thug. Don't even. No one's gonna buy it. He has no criminal history simply because he didn't get caught yet.
However, I think that a PR bond, or at least we're requesting that the court consider giving him a PR bond. My understanding is that he lives with his father. He's given me contact information for his mother, so he has good support from both of his parents. He is not working at the time, but Your Honor, just before even knowing where we were with these charges, I had a very serious conversation with Mr. Jones, in which I believe he was receptive to what I had to tell him. And we're going to work with Mr. Jones to figure out a different track, because if he's been able to do this well so far, he can do well much further. And it's going to just take a little bit of talking to and a little bit of redirection and connection with resources so that we can get him busy this summer and allow him to be able to stay out of trouble. I'd ask that the court consider allowing him to be released to his family. We did talk about a tether. If the court feels comfortable placing a tether on him, he states that he'd be able to abide by that. I don't know if there are any allegations of alcohol or drug use in this case. So we'd obviously ask that the court just put standard bond conditions on him.
All right. How about schooling? Did your client finish high school?
Did you finish high school? Yes, he did finish high school, but he's not working yet. Right, Darius?
Not right now.
When did you graduate?
Last year.
So what, May of 25?
Yeah.
And your client is related to a couple of the people listed in the no contact, I believe. Is that correct?
I would assume so. Darius, you heard the names that she called. Is Dominique related to you?
Dominique Jones, yes.
Yeah.
Okay,
Who is
what's
that to you?
That's my
Sorry.
sis- that's my older sister.
Do you live with her?
No.
I didn't catch all the names.
I'm sorry. I think,
There was,
I think one is Xavier Bonner. I think that's the person that was charged with the CCW. Arishon Coles. I don't believe that they are related. There is Trayvon Jones Williams and Tiedrion, Tiedrion, Devontae Young.
okay.
His last two names are the 17-year-olds. And the defendant was asking for his brother to be let go. So one of them might be a brother.
Presumably Trayvon Jones Williams.
Okay.
Thank you, Attorney Armstrong. So,
Mhm.
all right. Do you live with Trayvon?
He lived with my mom, but he'll like come to my dad's house sometimes.
Okay. And how do we say Mr. Young's name, since none of us seem to be able to do that?
Mr. Young.
Tiedrion?
Tiedrion? Okay. And Trayvon's New York.
See here. I believe I made then a error on the bond form. There was a lot of Jones names. So Dominique Jones, I believe, was one of the officers. I meant to put Xavier Bonner, which was the other person that we charged.
Oh, it was just a true case of keeping up with the Joneses.
So the officer is Dominique Jones.
Was your sister Dominique? Never mind. I'm not going to ask that. Okay.
Oh, I have
Nope,
this.
nope. Just stop right there. Thank you. Okay. Mr. Jones, have you put any thought into continuing your education, or you just want to look for work?
I wanted to go to college for trading.
Presumably you're not having a good time right now. I wouldn't think so.
Oh, man.
And presumably you don't want to spend a lot of time in rooms like that talking to people like me.
No, man.
Okay. So remember this. The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. Prior to your release, you're to be fitted with a GPS tether for home confinement purposes. You may leave your home to go to court, to go to testing, if you've got job interviews or community service. We'll get to that in a second. Or if you are trying to get into community college, if there's anything for that, I'll make a note. All of that would have to be approved through a tether agent. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Arishon Coles or Xavier Bonner. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. You are not to go back to that address where the fight occurred, that being on Concord Drive. When the court says do not go, the court does not care if you own a place, rent a place, or are personally invited to go to a place. Don't go. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards anybody whatsoever. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court. The next one in this matter will be the probable cause conference on June 18th. That also means going to community corrections as directed. If they haven't been already, you're also to have your fingerprints taken. You understand all of these bond conditions? Okay. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. So, Mr. Jones.
Yes, ma'am.
You are 19 years old, and I'm sure you've had people telling you what to do for most of your life, because that's just kind of how childhood works, and you are just barely coming out of that, whether or not it feels like it. And if you don't want to spend the rest of your life in rooms like this, having people like me telling you what you have to do and where you have to be, then do something different. Make better choices. All right? Okay. So, the court will set a $20,000 personal recognizance bond. So what that means is you're not required to post anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $20,000. You will sit a little bit longer to get the GPS tether. And hopefully all of this is a learning experience to never end up in a situation like this ever again. So, do you understand all of these conditions? Do you have any questions about anything that I have said? I need you to speak up a little bit.
How long I gotta sit? That's good.
So, it'll likely be till tomorrow morning.
Okay.
Okay. All right. Any other questions? Okay.
Your Honor, I do have a question. Is it a GPS or home confinement?
So home confinement, but there's a number of circumstances under which he can leave.
Got
So I said court testing if he's got any job interviews or school appointments to get into school. Also, I did and I almost forgot to say this, I would like Mr. Jones to look for some place to do some sort of community service, like an hour a week. And he can leave to do that as well.
Okay.
Okay. Anything from council?
No, Your Honor.
No, Your Honor. Darius, I'll call your mom and let her know, okay?
Okay. Mr. Jones, if you don't have any questions, then you are free to go to the door and tell the jail that you're finished.
How you doing?
Good morning. Give me just a moment. Can I have your name, please?
Xavier Bonner.
Just a moment, Mr. Bonner. Regarding Mr. Jones, when I was giving out the bond conditions, I don't recall if I specifically said no firearms, but please believe that is in fact one of the conditions is no firearms, all right?
Okay.
That's to the attorneys, Mr. Bonner. That wasn't for you. All right. Now calling the people of the state of Michigan versus Xavier Jaquan Bonner, Police Agency Report number 26-40725. Can I have appearances for the record, please?
Juan Armstrong on behalf of the people.
And Assistant Public Defender, Chinazi Kyriakin-Ruli, on behalf of Mr. Xavier Bonner.
All right. And Mr. Bonner, state your name for the record.
Xavier Jaquan Bonner.
Okay. Thank you very much. Today is the date set for an arraignment in this matter. Attorney Kyriakin-Ruli, did you want to address the plea?
Your Honor, in regards to the plea, we did not, I still don't see the charging document, but I don't have the charging document, so we'd need the court to read it to him.
All right. So what I have here is a felony complaint charging that on or about June 5th, 2026 at 1375 Concord Drive, that Mr. Bonner, you did with intent to use the same unlawfully against the person of another, go armed with a firearm. That is otherwise known as carrying a dangerous weapon with unlawful intent. That is a felony with a maximum potential penalty of up to 5 years in jail, a $2,500 fine plus court costs, or both. Do you understand what you're being charged with?
Yes.
And you understand the potential penalty?
Yes.
Okay. Count 2 is that you did carry a pistol, whether concealed or otherwise, in a vehicle operated or occupied by yourself, that being a Chrysler 300. This is otherwise known as carrying a concealed weapon. Do you understand that charge?
Yes.
And that is a felony with a maximum potential penalty of up to 5 years in jail, a $2,500 fine plus court costs, or both. Do you understand that?
Yes.
Count 3 charges that you did transport in or upon a motor vehicle a loaded firearm, which was not a pistol, that being, okay, not sure why that was there, pistol and or handgun, a Smith & Wesson M&P 40 handgun. This is otherwise known as possession of a loaded firearm in or upon a vehicle. Do you understand that charge?
Yes.
Okay. That is what's known as a high court misdemeanor. Basically, they are treated as felonies in this state. So there's a maximum potential penalty of up to 2 years in jail, a $2,500 fine plus court costs, or both the jail time and the fine.
Okay.
Do you understand all of that?
I understand.
All right. And all 3 of these counts require forfeiture of the weapon or devices involved. So you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that part doesn't apply to you, then don't worry about it. Do you have any questions about your rights?
No.
Okay. Now, because this is a felony case, you have the right in this matter to a preliminary examination that must be scheduled within the next 21 days. A
Wait,
preliminary.
you can continue. Thank you. About to explain.
I am. So, a preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed and that probable cause exists to believe that you committed the crime. So it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over. That is transferred to the circuit court, which is where your actual trial will take place.
Okay.
Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be June 18th, 2026. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail.
Okay.
Lastly, the court will set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So, can the attorneys address bond, please?
Yes, Your Honor. In this matter, the people are seeking a $20,000 cash or surety bond, drug testing, no contact order with the 15-year-old female witness, Arishan Coles. I did not put this on the bond form, but I am going to be asking for a no contact order with what is a sort of a co-defendant, Darius Jones, 19 years old, Trayvon Jones Williams, 17 years old, and Tierdron Devante Young, also 17, and a no-go to at the 1375, I think that's correct. Concord, I believe. Sorry. Yes, 1374 Concord Drive. In this case, there were multiple calls to 911 dispatched that there was a fight with several individuals at that Concord address. There was a report specifically that there was a male with red shorts and no top that had a gun in his waistband, and that several of these individuals fled in a white Chrysler. That is a white Chrysler that was later identified as being registered or owned by this defendant today. He was found in the driver's seat of the vehicle when the police approached at Bedford, which I believe is very close to that location. And he was also at that time wearing red shorts and no shirt. Upon a search of the vehicle, they did locate in the console a loaded handgun. There were two other handguns that were found just behind the, when you pull down the back seat, kind of in the trunk area. One was missing a magazine. The magazine was found on the floorboards of the back passenger seat. There were three males in the back seat, males that I had not mentioned their names. There was a female in the front passenger seat. I believe that she stated that was Ms. Sherry Young Klein. And I could be mistaken. I thought that she had stated that the defendant, Mr. Bonner, was either a partner of hers or they have a child in common. The defendant is 21 years old. He has a clear CCH. Also on the search of this vehicle, they found multiple bags of marijuana in the back seat. There was also information that when putting Trayvon Jones's phone in airplane mode, there are notifications on the lock screen for a police scanner app, which says it was a crime radar app. There was a notification sent out for an attempted break-in at Concord Drive home with a clip of the police radio traffic at that time. One of the guns was a ghost gun that had no serial number on it, is unable to be traced. And the other information that we have is that there was, the police also looked at the in-car video where Xavier Bonner was in the vehicle along with the 17-year-old Trayvon Jones. And they talked about poles, which officers stated is known slang for firearms or guns. Mr. Bonner stated that they are stolen guns. And they both talk about how they should have hid the guns in the house instead of in the back seat. They also discussed they should have stayed inside that house. There was a report by that 15-year-old female that at one point they were trying to fight inside the house and they were told to take it outside. Mr. Bonner says they should have ran. And then Mr. Bonner also states he knew the police were coming, which is why he parked across the street. We are requesting those bond conditions due to our concerns on this case. Allegations of stolen guns, allegations of using guns in a
Look at the look that Magistrate Braley has given this kid. She's not impressed.
fight. Again, no allegations that they were pointed at any person, but just that they were held onto or displayed or carried in a way to affect some sort of fear during this fight. It's very concerning. The defendant is 21, has a clear record, and potentially might have a child as well. And then also engaging in these behaviors with teenagers. So those are the reasons why we're asking for those bond conditions. Thank you.
And Your Honor, I had an opportunity to speak with Mr. Bonner today. Mr. Bonner does report he has one child. He also reports that he has a full-time job. He's employed at McDonald's. His son is 1 year old and they do live together in the same home. He says that he's got very strong family support. I also had an opportunity to express to Mr. Bonner my confusion as to how he finds himself in this situation at 21 with no previous criminal history whatsoever. I've explained to him how I've seen these types of situations start just like this, and then they trickle into murders. He expressed some, serious concerns and stated that, that is nowhere near where he wants to be. I'm hoping that, he can understand it's not too late to put together a plan.
All it would take is one time of someone disrespecting him, showing him some kind of disrespect when they're out there, bumping chests and talking all hot shit before the police come. That's all it would take. Or all it would take would be when they start running, when the police come and the police see the firearm in their waistband and they turn around to face the cop. That's it. They're done. They're done. But then the city riots and rages that it was the cops' fault.
For the fact that he does not have a criminal history. He has a 1-year-old child at home who needs him. He is gainfully employed and able to support his family. Funny, Your Honor, I asked him the same question you asked the other young man, if he likes where he is, if he feels comfortable there. And he indicated that that is not a place that he wants to see himself. So we're asking to give him another opportunity. We also spoke about the possibility of a tether. And he states that he understands that if the court requires him to wear a tether, that he would abide by the conditions of the bond.
Mr. Bonner, you look like you were going to add something when the attorney was saying something about your child.
I was just saying, not a son, I got a daughter.
Is it a girl? I apologize. Sorry.
And she's 1 year old?
Yes.
And she lives with you? Mom too?
You gotta use words, honey, so she can hear you.
All right. Mr. Bonner,
Yes.
the stakes here for you are incredibly high.
What does that mean?
It means you've got what amounts to 3 felony charges against you right now. There's the distinct possibility of jail time that would take you away from your child, who is 1 year old. So I shouldn't have to give you a whole lecture on how you really don't want to see yourself back in this place again.
Oh, never come back.
The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create weapons. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Arishon Coles, Darius Jones, Trayvon Jones Williams, or Tiadrian Young. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to Ms. Cole's residence, that being the Concord Drive address. The same goes for the Jones addresses and the Young address as well. You're not to go to any of those locations. When the court says do not go, the court does not care. If you own a place, rent a place, or are personally invited to go to a place, don't go. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards anybody whatsoever. You are not to engage in any sort of criminal activity whatsoever. Excuse me. You are to appear for any and all dates set for you by the court, the next one in this matter being the probable cause conference on June 18th. That also means going to community corrections as directed. If they haven't been already, you're also to have your fingerprints taken. Do you understand all of these bond conditions?
Yes, ma'am.
Do you have any questions about them? Use your words, please.
No.
Thank you. All right. So, since I think it has already been discussed that you don't like being in that room and you don't want to keep having to talk to people like me for the foreseeable future or the rest of your life, make better choices in the future. At this time, the court will set, excuse me, a $30,000 personal recognizance bond. So what that means is you are not paying anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $30,000. I should also note that these conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. I also want you to try to find some place to do community service, just an hour a week. All right. Any questions about anything I said? Speak up a little bit for the record, please.
No.
Okay. Anything else from counsel?
Your Honor, is the court going to give him some sort of tether? Or not on this case?
No, I'm not ordering a tether for Mr. Bonner at this time.
Thank you.
Attorney Akiri, I can relate.
No, Your Honor. We're all set.
All right. Thank you. Then, Mr. Bonner, if you don't have any questions, you're free to go to the door and tell the jail that you're finished.
Thank you.
You're welcome.
Mr. Bonner, please call my office tomorrow morning, okay?
Okay.
Okay.
Hello.
Good morning. Would you be Ms. Labrelle?
Yes.
Now calling the people of the state of Michigan versus Janine Babette Labrelle, Police Agency Report number 26-27857. Appearances for the record, please.
Ron Armstrong on behalf of the people.
And Assistant Public Defender, Chinatha Kiriak and Ruli on behalf of Ms. Labrelle. Your Honor, we did not have an opportunity to review the report, so we'd ask the court to read it.
All right, thank you. Give me just a moment. All right. What I have here is a felony complaint charging that on or about June 6th of 2026 at or near North Main and Catherine, that Ms. Labrelle, you did in the course of committing a larceny of a camera and or GoPro use force or violence against a person present, that being Everett Christopher Peabody. This is otherwise known as unarmed robbery. Do you understand what you're being charged with?
Not entirely.
Okay. So when I ask that question, I'm not asking if you agree with the charge or even if you necessarily understand why you're being charged with it. I just want to know if you understand what it is you are being charged with.
No, I do not.
Okay. So this count is stating that in the course of committing a larceny, that is stealing a camera or GoPro, that you used some form of force or violence against the person who had the camera or the GoPro. Hence, unarmed robbery.
How much you want to bet the guy was filming her and she Karened out and tried swiping the camera from him, or actually did get the camera from him and now has unarmed robbery charges?
You didn't use a weapon per the complaint. Do you understand what you're being charged with?
Yes.
Okay. This is a felony. It has a maximum potential penalty of up to 15 years in jail. Do you understand that potential penalty?
Yes.
Count 2 charges that you did make an assault or an assault and battery upon Everett Christopher Peabody. That is a misdemeanor with a maximum potential penalty of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that charge?
Can you repeat it, please?
Yes. It is that you made an assault or an assault and battery upon Everett Christopher Peabody.
Okay. And then what was can you repeat the end?
The potential penalty for this misdemeanor is up to 93 days in jail, a $500 fine plus court costs, or both the jail time and the fine.
Or wait, 93 days or $500?
Or both.
Or both?
Or both. That's the maximum potential penalty. All right. So the point of the hearing today is to tell you what you're being charged with and what the potential maximum penalties are. All right. This does not mean this is what is necessarily going to happen. It is just potentially what could. All right.
Okay.
Okay. So
She's in a lot of trouble over a bad decision. Regardless what it was, whether I'm right about her getting mad at somebody filming her or not, maybe she saw a camera, laying next to a beach towel and thought, "Ooh, cool, free camera." We don't know. But whatever it is, she's in trouble over her own actions, and I don't feel sorry for her.
do you understand both
Yes.
of counts that you're being charged with. All right. And
Yes.
okay. And the potential penalties associated with them.
Yes.
Okay. So you do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, then don't worry about it. Do you have any questions about your rights?
I'm not sure what questions to ask.
Okay. So the public defender's office is being appointed to your case at this time. So if you have questions more about what all of this means, you can talk with an attorney later. Okay. If you don't have any immediate questions about those rights, I'm going to continue.
Go ahead.
So, because this case is a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed, and that probable cause exists to believe that you committed the crime. So, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is, transferred to the circuit court, which is where your actual trial will take place. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be June 18th. Again, that is June 18th, 2026. That will be at 9 in the morning in person at the 14A1 District Court in courtroom C. So 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So, can the attorneys address bond, please?
Thank you, Your Honor. The people are only requesting no contact orders with Autumn Jorah Joy Price and Everett Christopher Peabody. We have no objection to a PR bond.
Right.
And Your Honor, we're obviously asking for a PR bond. Ms. Labrelle has no criminal history. She's local to the Ann Arbor area. She's gainfully employed. I don't know if the court took the swear to this case. Okay. All right. So we're just asking for a PR bond, Your Honor.
All right. The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Autumn Price or Everett Peabody. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact on the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. This also means if you see them on the sidewalk, you turn around and you walk yourself in the opposite direction. You are not to go to their places of residence, places of work, any place they might frequent. When the court says do not go, the court does not care. If you own a place, rent a place, or are personally invited to go to a place, don't go. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Autumn Price, Everett Peabody, or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being the probable cause conference on June 18th. If they have not been already, you are to have your fingerprints taken. I'm also going to make a note that there should either be a CMH referral and or if you aren't already, you should look into some sort of therapy or counseling.
On the plan.
Move it up the list of priorities. These conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you violated one of these conditions, then they may arrest you on the spot. You'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. Do you understand all of these bond conditions? Speak up a little bit, please.
Oh, yes.
Okay, thank you. All right. At this time, the court will set a $50,000 personal recognizance bond.
Whoa, wait a minute. How is it that this woman who did not have a weapon, who did not engage in group activity, if you want to use the prosecutor's words, how is her one bond the same amount as the two individuals that we just watched that had ghost guns and ammunition and guns tucked in the back of the seats and bags of marijuana all over the back of the car, who were engaging in violent thug behavior? And they got 20K and 30K. But she, this woman who stole a GoPro or camera with no weapons, is 50K. Something's a little off there.
So what that means is you're not required to post anything to get out.
Okay.
Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear, or if you violate any bond conditions, a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $50,000. Okay. Anything from counsel?
No, Your Honor.
No, Your Honor. Thank you very much.
All right. Ms. Labrelle, if you don't have any questions about anything that I have said, you are free to go to the door and tell the jail that you're finished.
Janine, get the number to my office, but from the jail, and call us Monday morning, okay?
Okay.
Okay.
Good morning. Can I have your name, please?
Crystal Lewis.
Okay. You. Now calling case number 25F31256. This is the people of the state of Michigan versus Crystal Marie Lewis.
Juan Armstrong on behalf of the people.
And Assistant Public Defender, Chinaza Kyriakin Ruli, on behalf of Ms. Lewis.
Right, thank you.
Your Honor, that was the LN 186-24. Is that what you said was the case, the police agency?
That is correct. The police agency report number is LN 186-24. It does have a case number at this time, that being 25F31256.
Okay. Your Honor, in regards to the plea, we do stand mute, waiving formal reading, asking the court to enter a not guilty plea on her behalf.
All right. Thank you. So, Ms. Lewis, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No.
Thank you. Okay. And because this is a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed and that probable cause exists to believe that you committed the crime. So, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over, that is transferred to the circuit court, which is where your actual trial will take place. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be June 18th, 2026. That will be at 9 in the morning in person at the 14A1 District Court in courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So, do the attorneys wish to address bond, please?
Your Honor, in this case, we are requesting a referral to community corrections for drug and alcohol testing. It's alleged that this was a traffic stop. She was found to be in possession of drug paraphernalia by having what they call a crack pipe in the front right pocket of her sweatshirt. She denied ownership, but then admitted that there were 2 more in her purse, also denied ownership of those ones. 3 more crack pipes were found in her purse with a white tube that had cocaine inside of it. I don't see any priors in terms of drug cases. It looks like she did have pled on a retail fraud in 2023 out of Pittsfield. Thank you.
And Your Honor, I had an opportunity to speak with Ms. Lewis. Ms. Lewis reports that she is a mother of, I think it's 2 young children, Ms. Lewis?
Yeah.
Okay. So she states that the children are currently with, I believe their father. I don't think that there's anything severe on it. Can the court hear me? It says my internet connection is unstable. Can you hear me?
You were breaking up a little bit.
Okay, sorry about that. Your Honor, we're asking for a PR bond. I did not set Ms. Lewis's expectations in regards to community corrections responsibilities and testing. I will note that she has a hold out of Livingston County. She says she's not familiar with that case. I believe it may be it says contempt of court, but I believe that's for failure to appear in a hearing that she may have had scheduled out there. She understands that if she is released from here, that she may be sent over to Livingston if they come and pick her up. She was actually transferred to our jail from Canton Jail. She had posted a bond out there. It's a retail fraud matter. She states that she sold her vehicle in order to get that bond money, but she does not have any more money to post at this time.
All right. The warrant out of Livingston is out of the 44th Circuit Court.
I have banned the newest attendee for inappropriate comments. I will not tolerate racist comments on this channel. You want to make comments like saying that white people are better than black people, you can go fuck yourself.
And Howell.
What did you say, Your Honor? I missed that.
The bench warrant is out of the 44th Circuit Court in Howell for failure to appear for a circuit court motion on the people's emergency motion to revoke bond last year.
Okay.
And it does indicate that they'll pick up statewide.
Okay.
Attorney Kiriakin, did you indicate whether or not your client's currently employed?
No, she is not employed. Well, she was doing DoorDash previously, but not right now. She'd have to figure out about transportation again.
Okay. All right. The court will set bond with the following conditions. Ms. Lewis, you are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to Community Corrections for drug and alcohol testing. You will need $12 and a photo ID. That is to be intensive supervision. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. You are not to leave the state of Michigan without the court's permission. You are not to engage in any sort of assaultive behavior or any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court. The next one in this matter being the pretrial the probable cause conference on June 18th. That also means going to Community Corrections as directed. Prior to your release, you're to be fitted with a GPS tether for home confinement purposes. You may leave to go to court, to go to testing, to go to treatment. If they haven't been already, you are to have your fingerprints taken.
Oh,
At this time, the court is setting bond in the amount of $10,000. 10% is allowed, and release to treatment is to be considered. Anything from counsel?
Nancy.
I didn't hear you, Your Honor.
I asked if there was anything from counsel. You did hear the bond?
I did hear the bond, 10,000, 10% with release to treatment. Yes. Nope, we are all set.
Thank you, Your Honor. Nothing further.
Okay, thank you. Ms. Lewis, you are free to go to the door and tell the jail that you're finished. Good afternoon. Can I have your name, please?
Demetrius Hudson.
All right. Now calling case number 25F55260. This is the people of the state of Michigan versus Demetrius Hudson. Police agency report number 13-640-24.
Paul Armstrong on behalf of the people.
And I think Attorney Kiriakin really froze again. Okay. Attorney Kiriakin.
Wait, yes, okay.
Yep.
Assistant Public Defender Chinazi Kiriakin on behalf of Mr. Hudson.
All right. And do you want to address the plea?
Yes, give me 1 second, Your Honor. On Hudson, I believe Yep, Your Honor, we waive formal reading, stand mute, asking the court to enter a not guilty plea on his behalf. This is on MSP 13-640-24.
Correct.
Okay.
Yes. Did you need the case number again?
Yes, please.
25F55260.
Perfect. Okay, thank you.
All right, thank you. Mr. Hudson, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No, ma'am.
Okay. So, because this is a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. A preliminary examination is a hearing held before a judge where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime was committed and that probable cause exists to believe that you committed the crime. So, it's a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that it is strong enough, then the case will be bound over. That is transferred to the circuit court, which is where your actual trial will take place. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be June 18th, 2026. That will be at 9 in the morning in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail. Lastly, the court will set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates, and the other is for the protection of the public. So, can the attorneys address bond, please?
Yes, Your Honor. In this case, the defendant was charged with a CCW offense. This appears to have been submitted to our office back in 2024, so it is an older case. I don't have an updated lien since then, so I'm not certain how he got into custody at this time. It appears we did charge this case in 2025, so maybe about a year ago. I do have some concerns in this case. Now, the bond form is asking for no assaultive behavior, no weapons, no contact with the co-defendants. It doesn't name them. I have those names here. They are Kylie Deshawn Burton and Jamal Jones. I can spell that. Kylie, Kylee Deshawn Burton, and Jamal Jones, Jamal Jones, common spelling. The bond form also requested no alcohol or drugs. I did not ask for any sort of cash bond. I do have some concerns, and I think the court should perhaps consider a cash bond if the court, especially if it has updated information on how he came into custody and any updated lien. There was a report of a theft of a gun store. Several suspects involved in a B&E of a gun store in Blackman Township. Several guns were stolen. One was subsequently used in a homicide in Jackson City on January 30th, 2024. The police received information that the suspects of this theft were staying in Ann Arbor. They performed search warrant or surveillance on this location and obtained a search warrant. 3 subjects exited the residence or that location. They entered a Chevy Cruze. They did a traffic stop. The defendant was found. He was in the front passenger seat. There was a weapon under his seat, a handgun loaded with a round in the chamber. The driver was Burton. He had a handgun in his right front coat pocket, loaded and a round in the chamber. That gun was reported stolen. The rear passenger, Jones, was found to have a gun in his right front pants pocket, loaded with a round in the chamber.
And you'll be lucky if you don't go down for that homicide.
I don't see any criminal history. I don't have any update on this theft, but I do have serious concerns, even despite the age of this case. Thank you.
Your Honor, I had an opportunity to speak with Mr. Hudson. I think the first thing that I wanted to know, and I just sent Ms. Armstrong a message about that. My client's age at the time of this offense was 17. The date of offense here is the 1/30/2024. But he's got a date of birth of 8/20/2006. My math is not the best, but I believe that should put him at 17 when this occurred.
17 years and 5 months. Nearly 18. There's no reason he can't be tried as an adult.
I don't know if that or what that means for us in this proceeding.
Honestly, I don't either. So
I don't either. Okay, let's see here. There are a lot of police reports that I was not able to review. Okay, it says 8/20/06 for date of birth.
Yes, right, Mr. Hudson?
Yes.
8/20/06. And then I don't know how to math.
I just subtracted 2006 from 2024.
I used to have a thing that I could calculate ages.
Yeah, I was 17 around that time.
That would make sense. I will have to, okay. I will let my office know. I don't know if there's something that I didn't see that they made a decision to charge him already as, oh goodness. Okay.
I should have messaged you earlier, Fawn, when I found out it was you. I apologize. It fell off of my radar until his case was called.
Well, we had a lot of cases today, so we've been busy. I'm just gonna make sure I put this note. 8/20/06, January 30th. Okay, 2024. I don't really handle juvenile cases, so I'm not that familiar. So 17 years, 5 months. So 17 years, 5 months. Years, 5 months. Where's the complaint? There's no notes on my end. Okay, who charged this? Okay. 80 years Mirsky. I will have to get a hold of people in my office, Ms. Reiser and Ms. Rizmersky, and see how they want to handle this. I don't know if this is something where we can put off the arraignment to tomorrow to ensure that we're doing the right thing, or we have the right, because this is not even on it's not on a juvenile complaint either.
Yeah, I
No.
saw that too.
Just hold up a second, please.
One thing I don't like about those MSP police reports, because they don't automatically calculate the age like all the other agencies do.
Got it.
So I'm wondering if they just missed it or if they made some sort of decision to charge him. But that's not the right process.
No, I think he's considered an adult under Michigan law.
Okay. At 17?
But I'm trying to confirm, so just give me a minute.
Right, thank you. Yeah, I don't think that this falls under the designated waiver specified juvenile violations.
That's what I'm seeing.
Automatic. Yeah, there's no automatic waiver. It's not specified juvenile violation. First degree arson, murder. Okay. Okay. Well, then we will have to, we'll have to redo this. We'll have to do a petition to the family court. What does that mean for today?
Well, it means I can't arraign him at the least.
Right. Because if you'll have to do another swear to.
Oh shoot, that's that case. I was supposed to.
Sorry right.
And that's why I asked them
Yeah, they cut the feed at that moment.
who the APA was. That was what I was supposed to do with that information. That's what
I'll take care of
Sorry.
it. All good.
Thank you. Thank you.
I think I need a nap after this.
Absolutely.
Me too.
Yeah, no, I'm pretty sure Mr. Ferret over here is in agreement as well. So we just have one more and it's a misdemeanor. Good afternoon. Give me just a moment. Okay, then I just put something. Hopefully, let me know if you need me to do anything else. All right. Okay. Sir. Good afternoon. Am I unmuted? Yes. Can you tell me how to say your last name, please?
Indianabong.
Indianabong?
Yes.
Okay. And can you spell it for me? Because I had a couple different spellings.
Okay. N for Nancy, D for dog, I for iron, A for apple, N for Nancy, A for apple, O for orange, B for boy, O for orange, N for Nancy, and G for God.
Okay. All right. Thank you. All right. This is the people of the state of Michigan versus Joseph Tom Indianabong. Police Agency Report number 26-41122. Appearances for the record, please.
Fawn Armstrong on behalf of the people.
And Assistant Public Defender Chinazi Kyriakin on behalf of Mr. Indianabong.
Okay. So today is the date set for an arraignment in this matter. Attorney Kyriakin, did you want to address the plea?
Yes, Your Honor. Well, we didn't have an opportunity to review it.
Okay. So what I have here is a misdemeanor complaint that charges that on or about June 6th of 2026 at 2900 International Drive, Mr. Indiabong, you did willfully and maliciously destroy or injure an automobile, that being a 2021 Ford Edge, the personal property of Naftali Rikanga, and the amount of the destruction or injury was $200 or more, but less than $1,000. This is otherwise known as malicious destruction of personal property. Do you understand that charge against you? Okay. Are you able to hear him? Okay. I need you to speak up for the record, please.
Yes, I understand.
Okay. Thank you. As I said, this is a misdemeanor. It has a maximum potential penalty of up to 1 year in jail, a $2,000 fine.
That face, that's the face of someone who's not faced consequences for their actions and didn't realize what the consequences are going to be when they had their little temper tantrum.
Oh, take deep breath. Okay, take a deep breath. This is the potential maximum. This does not mean that is absolutely what is happening to you. Okay, I am telling you the potential of what could happen, the maximum. All right. So, a $2,000 fine or a fine of 3 times the amount of the destruction or injury, whichever of those two amounts is greater, plus court costs, or both the jail time and the fine. So, do you understand that potential maximum penalty? All right. Okay. You do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that part doesn't apply to you, then don't worry about it. Do you have any questions about your rights? Okay, I do need you to use your words, please. Any,
Who's that?
do you have any questions about your rights? You do have a public defender that's been appointed to you.
Okay, I don't have any question now.
All right. So at this time, the court is going to schedule a pretrial conference that is going to be June 15th, 2026. That will be at 9 in the morning in person at the 14B District Court in courtroom number 1. You're going to get paperwork for all of this as well.
Okay.
All right. So, do you know where 14B is located?
No, I don't know, but
Okay. So, like I said, you'll get paperwork. The address will be on your paperwork, but if you know where the Whitaker Road Kroger or the Whitaker Road Library are, it's over there. Okay. There's a big pond out front.
okay.
Okay. So, the court is going to set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. So can the attorneys address bond, please?
Yes, Your Honor. In this case, it is alleged that there were a few calls to 911 regarding a report of people fighting outside. I believe this is a kind of apartment complex and near a pool area. When police arrived, they saw two black men standing next to the pool. They were observed to be both injured and both bleeding from the mouth. One of the men is Mr. Graysadu Ketty, and he stated that it was his birthday. He invited his sister over. Sister is Neftali Amara Rakanga, and he stated that Ms. Rakanga is dating the defendant. So the defendant also came over to his apartment. They both drove their own vehicles there, so separate vehicles, but there was some sort of argument at some point. It wasn't quite clear, but at some point it was alleged by Mr. Ketty that the defendant in anger went over to his girlfriend's vehicle and ripped off the driver's side door handle. There is a picture of it. It is completely off. And after that point, both Mr. Ketty and the defendant started to fight. Mr. Ketty did not want to press charges for the fight. So based on that, we don't seem to have much of a criminal history. There's a traffic offense from earlier this year in 35th District Court. We're asking for a no contact order with both Neftali, Nephthalie, Amara, Emmera, Rakanga, Rekanga, and Graysadu Ketty. I believe that's on the bond form, so I don't know if I need to spell it, but I can if the court requires me to. And the address for both of them on the police report is listed as apartment 317B in Ypsilanti. So we're asking for a no go to that address. I do believe that is Mr. Ketty's address. It is from the police report. They did have a lot of difficulties communicating with Miss Rakanga. So I'm not certain if that is her address or not, but that is what's listed on the police report. So I'm asking for the no contact orders and that no go to. And I also do understand that the defendant does also live in it, but in a different building, it appears.
And Your Honor, that's the information that I had too, is in regards to where he lives. He just says it's a different building, but the same complex. He reports being gainfully employed. No criminal history, Your Honor. I do have some referrals that I do plan to make for him. We're asking for a PR bond in this matter.
All right. So, Attorney Akiri, can relate, do your client and Ms. Rakanga live together?
They do not.
Okay. Do they have any children in common?
No, they do not, Your Honor. Is that right?
Okay. You don't have any children with Ms. Rakanga?
Well, she has kids. She has children.
But do you have children with
But
her?
are they yours?
No, me personally, I don't have children, but I'm with her, so I'm just,
So no, Your Honor, they do not.
I
Okay.
just
I
know.
apologize.
I just
All
know.
right. Okay. Does she live with you or do you live with her?
No, we don't live together, but we see each other.
And Mr. Ndiabang, would you find it helpful to have an interpreter in the future?
No, I'm good with English.
Okay. You are. I just want to make sure for legal purposes that you don't want extra assistance. So,
Okay.
all right.
Thank you.
The court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Neftali Rekanga or Grasadu Keri. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form, or through third parties. Given that you all reside in the same apartment complex, what this effectively means for you, if you see either of them, you have to leave. You can go back into your apartment and lock the door. If either of them call you, you don't answer the phone. Basically, for right now, they do not exist.
Okay.
You are not to go to either of their addresses or places of work or any place they might frequent. If that means you don't get to go to the pool for now, then you don't get to go to the pool for now. When the court says do not go, the court does not care if you own a place, rent a place, or are personally invited to go to a place. Do not go.
Okay.
You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behavior towards Ms. Rakanga, Mr. Keddy, or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, the next one in this matter being June 15th at 9 a.m. at 14B. If they haven't been already, you are to have your fingerprints taken.
Yes,
Okay. Do you understand all of these conditions?
I do.
Okay.
Yes.
Thank you. So these conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you violated one of these conditions, they can arrest you on the spot and you'll be held for a bond violation hearing in front of a judge who may revoke your bond and set a new, more restrictive one. At this time, the court will set a $10,000 personal recognizance bond. So what that means is you are not required to pay anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $10,000.
Yes, ma'am, I understand.
Okay. Any questions about anything I've said?
No question, I understand everything now.
Okay, thank you very much. Anything else from council?
No, Your Honor.
No, Your Honor.
All right, thank you then. Mr. Ndiabong, if you don't have any questions about anything I've said, you are free to go to the door and tell the jail that you're finished.
Thank you.
Okay, thank you.
Mr. Ndi.
What I suspect, since I think she just froze again, she has been asking.
Yeah, I'm gonna call my office tomorrow.
Call her office. It's the public defender's office. There should be a phone
Thank you,
number posted
yeah.
around the jail.
Okay,
Okay,
okay, ma'am.
all right.
Thank you.
Thank you.
Thank you so much. Thank you. Thanks all.
All right, you're
Okay.
welcome. Have a good one.
Thank you. Okay, I believe that was our last one. I'm removing the jail and prior to me ending the Zoom, I just want to tell people they need to come get their children.
I love that. I just want to tell people to come get their children. Well, you got enough 17-year-olds thugging around getting locked up in Michigan right now. So, yeah. How about people handle that?
Good morning, sir. Please state your name. Sir, please state your name.
Maurice Giles.
All right, Mr. Giles, thank you for that information. Calling case number 22-894, people of the city of Rochester Hills versus Giles. You've identified yourself. This is a bench warrant. Counsel, please put your appearance on the record. How'd you like to proceed?
Good morning, Judge. Richard Lender, Mr. Giles. Waive the reading of the complaint and warrant, stand mute.
Our honor not guilty plea for purposes of arraignment. Does Mr. Giles want a court-appointed attorney going forward? Does he qualify?
Yes.
All right, we'll refer this for assignment of counsel. Looks like bond was set at an amount of $688. My inclination is to continue that, but I'll listen to your argument.
Judge, I would just indicate that this is a 3-year-old case, 4-year-old case, I'm sorry, 2022. I'm asking for a personal bond in this case. Just a matter of money owed.
All right, I appreciate the argument, but with defendant failing to appear previously, the court's got to be assured that he's going to appear as ordered. So I'm going to continue the bond, $688 cash for surety, with all previous conditions continuing. You'll be notified of your next court date, Mr. Giles. Push on the door, that you'll be by now.
I've done time on this case before.
You'll be able to discuss that with the judge when you see the judge.
That I've been doing time on because you motherfuckers want money that I don't have. I lost
You're all set,
both of my
Mr. Giles.
cars for some bullshit like this. And they fucked up my license. And that should have been cleared up a long time ago.
I appreciate your concern, Mr. Giles. You're all set.
I don't mean to be cussing, man, but this is a bunch of bullshit.
All right.
Y'all put people through bullshit, and then we got to go through this whole shit. Because all y'all want is motherfucking money.
Anything else, Mr. Giles?
What kind of money do I owe you for a motherfucking old ass ticket for you to put a bench warrant after I done did time to been to court on this shit before, and it did time on this probably same goddamn case.
Duly noted, Mr. Giles. You're all set. If you push on the door, that will be by to help.
Yeah, okay. Money hungry bitch.
Giles, you done?
Yeah.
Boy, Mr. Clancy, you really got him upset.
$688. You can help him out.
I think that's like $10 per curse word. Detective, can you hear me? Looks like you're muted.
Let me see here. Yeah, I think
All right,
you hear me now?
I can hear you now.
Okay.
Yep. You're calling in on the square twos for Majet and Threlkeld.
Yes.
Who would you like to do first?
We can take care of Threckeld first, I guess.
Alrighty, calling case number 26-21630, State of Michigan versus Deon Terrell Threlkeld. Detective, please state your name for the record.
Brett Roberts.
All right, do you solemnly swear affirm the testimony you're about to give us to the best of your knowledge, information, and belief?
Yes.
Please proceed with the facts to establish probable cause.
Yes, on June 5th, 2026, deputies were dispatched to 429 Elizabeth Lake Road in the city of Pontiac. It's a diner. They were dispatched for a larceny from a building which occurred on 6/4. Deputies observed video footage of a black male entering the store, looking around. After seeing no one was watching, he takes approximately $30 in the tip jar. The owners recognized the subject because he lived right behind the eatery. Deputies contacted the suspect. He admitted to stealing the money. He was taken into custody and taken to OCJ.
All right, the court finds the alleged crime was committed. There's probable cause to believe that the defendant committed it. And reviewing his record, he's he's got just like one prior shoplifting, one prior retail fraud. Is that correct? He doesn't have any, that's the only warrant he's got out right now?
Yeah, I think that's it. Yeah, he's pretty minor, but I guess you got to start somewhere.
Yeah, my inclination is some sort of low cash bond, like 5,000, 10%,
Yeah,
something
yeah,
like that.
he's not
Just
violent.
because because that other bench warrant's been out there since 2024, so I don't want to give a personal. So
Yeah, he's,
anyway, those are my thoughts. I'll listen to the argument of his attorney, but is that something you think would be reasonable?
yeah, he's like, and I mean, it helps him. He admitted to doing it, so it didn't seem like a terrible kid.
All right.
Yep, you're gonna see the magistrate.
Okay.
Morning, sir. Please state your name.
Leon Thurkel, how are you doing today?
Pretty good. All right, thank you for that information. This is case number 26-21630, State of Michigan versus Threlkeld. Counsel, please put your appearance on the record. How would you like to proceed?
Yes, good morning, Richard Glenn, Mr. Threlkeld, way reading the complaint of warning, stand mute.
All right, letter of plea not guilty for purposes of arraignment. I'll advise Mr. Threlkeld, he's presumed innocent to proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination within 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford counsel, court, or appoint one for him. Mr. Glenn, does Mr. Threlkeld wish to have a court-appointed attorney going forward, and does he qualify?
Yes.
All right, we'll refer this for assignment of counsel. With respect to bond, my inclination is to set some sort of low cash bond due to the fact that he does have a current bench warrant out for him, but I'll listen to your argument.
I would just ask for a personal bond in this case. Pretrial Services recommends a personal bond with conditions. He is employed, he has no prior felony record. Thank you.
All right, the court does note there's a warrant out from 2024 for a retail fraud offense. So in order to ensure Mr. Threlkeld's appearance, I'll set bond amount of 5,000 cash 30 or 10% with the condition that Mr. Threlkeld not return to Slate Eatery, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or phone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or legal drugs, new criminal offenses, and pretrial services supervision. All right, Mr. Threlkeld, you're all set. If you push on the door, deputy will be by to help.
All right, thank you.
Okay, good luck.
You guys have a good.
You too. All right, great. So then we move on to case number 26-21633, State of Michigan versus Jalan Devante Majet. Detective, if you've identified yourself for the record and you've been sworn, please proceed with the facts to establish probable cause.
Yeah, on June 5th, 2026, deputies were dispatched to 85 Pine Grove in the city of Pontiac on the reports of a domestic violence police call. Deputies arrived at the location and spoke with the victim, Keila Grandison. She stated she resides at the residence with her boyfriend, Jalen Majet. They got in an argument. She told him to get his things. He went outside. She said he didn't get all his stuff back. He kicked the door and allegedly slammed her up against a wall. Then she stated that on 6/3, they were involved in a physical altercation in the bathroom of their residence where he choked her unconscious. Deputies observed bruising on her neck. Majet denied claims. He was subsequently arrested and taken to OCJ. He has 3 prior DV convictions. He is going to court on Monday for another case involving the same victim, domestic violence. So this will be his fifth pending charge. 3 already charged. He'll probably get convicted of the 4th. So this is his 5th DV charge.
All right, the court finds the alleged crime was committed as probable cause to believe the defendant committed it. As far as bond goes, my inclination is like GPS tether and like in the neighborhood, like 50,000 cash, sure, 10%. What are your thoughts with respect to bond?
That makes sense because he's clearly not learning his lesson.
Right. Okay. All right. Thank you very much for calling in. Have a great rest of your weekend.
You too, sir. Thank you.
All right. Take care.
Yep, you too. Bye.
Judge, we're ready, all of them.
All right. Awesome. Thanks.
Giles, no, let's see, who's first? Majet's in the box.
All right, gotcha. All right, sorry, Mr. Majet. Are you Mr. Majet?
Yes, sir.
All right, thank you. Calling case number 26-21633, People State of Michigan versus Jelani Majet. If you identified yourself, counsel, please put your appearance on the record. How'd you like to proceed?
Good morning, Richard Glenn, Mr. Majet. Wade reading the complaint and warning, stand mute.
All right, I will enter a plea of not guilty for purposes of arraignment. I'll advise Mr. Majet he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination where the prosecutor must establish that these crimes were committed and there's probable cause to believe he committed them. He's got the right to try these matters by judge or jury. He's got the right to remain silent. If he decides to remain silent, that cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one, the court appointment for him. Mr. Galana, does Mr. Majet wish to have a court-appointed attorney, and does he appear to qualify?
Yes.
Okay, very well. We'll refer this for assignment of counsel. Yeah, based on the record and the recent activity of Mr. Majet, I've got some grave reservations regarding bond, but I'll listen to your argument.
Judge, I would just ask for a reasonable bond to be set in this case. Mr. Majet is employed. So we're set for a reasonable bond, Judge. Thank you.
All right, I do know the defense currently out on bond for a domestic violence third. He's on probation on the Sixth Circuit for a domestic violence third. He's got a violation of probation hearing set for this week, presumably on another domestic violence case. He's got 35 prior convictions. So in order to assure his appearance and protect the public, the court's going to set bond amount of $50,000 with a conditions that he not have any direct or indirect contact with Kayla Granderson, that he not harass or intimidate any witness, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs, new criminal offenses, pretrial services supervision, GPS tether prior to release that would allow Mr. Majet to go to court, medical appointments, and work. Next court appearance is a probable cause conference set for June 18th at 1:30 p.m. His exam set for June 25th at 9 a.m. Both of those at the Pontiac District Court. All right, you're all set, Mr. Majet. If you push on the door,
So
you'll be by to help.
50, you said 50,000
Yes,
cash surety, no 10%?
correct,
And you said I gotta get a tether?
correct.
Okay.
All right. All right, if you push on the door, deputy will be by to help.
I already am also.
Last one.
Yep. You know, it's not the quantity of people today, it's the quality.
Pardon?
It's not the quantity, it's not the large number of people, it's the quality of the people that
Right.
visiting with. All right. Are you Mr. Dominic Covert?
Yes, sir.
Okay, great. This is case number 26KH65, Kego Harbor versus Covert. Have you identified yourself for the record? Counsel, please put your appearance on the record. How'd you like to proceed?
Yes, Richard Glander for Mr. Covert. Wade reading the complaint and warning, stand mute.
All right, I'll enter a plea of not guilty for purposes of arraignment. I'll advise the defendant he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford counsel, court appoint one for him. Does Mr. Covert want a court-appointed attorney going forward, and does he qualify?
Yes.
All right, we'll refer this for assignment of counsel. My inclinations of personal bond with standard conditions. I'll listen to any argument you may have, Mr. Glenda.
I'd ask for a personal bond. Pretrial services recommend same. Judge, this is a misdemeanor offense. I'm not aware of any prior record. Thank you.
All right, I'll enter a bond of $5,000 personal. So, Mr. Covert, you're not gonna have to post any money to be released today. Conditions are you're not to have any direct or indirect contact with Jasmine Colbert or Zachary Santiago. Not to return to 2929 Pridham, may return one time with police escort to retrieve personal items. Must not harass or intimidate any witnesses. You must appear for any court proceeding, not leave the state without permission of the court. Notify the court in writing of any change of address or phone number. Not possess firearms, other dangerous weapons. Refrain from using any alcohol, marijuana, or legal drugs, no criminal offenses. and you'll be supervised by pretrial services. All right, you're all set, Mr. Covert. If you push on the door, a deputy will be by to help. Good luck to you.
Your Honor, I have a quick question real quick. Can I ask
What's
you?
that? Sure.
All my personal belongings, my phone, my wallet, my ID is everything at the house. So how do you say I can get it?
You get one visit with a police escort to retrieve any personal items from the home that you may need.
Will that be today?
Whenever you can set it up with the police department.
Okay, thank you.
Okay, good luck, Mr. Covert.
Okay, thank you,
Thanks.
Your Honor.
All right, thanks, Mr. Glenda. We'll set tight for now. I believe we're all caught up.
All right.
Yep, all set.
Let's go to.
Good morning. Can you hear me?
I can. Can you hear me, Your Honor?
Yep, you're calling in to do the swear to on Andrew Benson.
Yes, Your Honor.
All right, it's prosecutor order number 26-21622, State of Michigan versus Benson. Detective, please state your name for the record.
Detective Scott Turner.
All right, do you solemnly swear affirm testimony you're about to give to the best of your knowledge, information, and belief?
I do, Your Honor.
Please proceed with the facts, establish probable cause.
On 6/6/2026, approximately about 3 o'clock in the morning, Officer Pavone and Densmore were dispatched to the area of 24771 Coolidge in the city of Oak Park for an area check where they were reported of a male and female were arguing, and the male had thrown keys at the female. Officer Pavone had located the male identified as Andrew Benson, 10/24/1991, and the female identified as Candace Nichols in the area of 10 Mile in Coolidge. Officer Pavone spoke to Candace Nichols, who stated that she and Benson had been dating and that while driving along 10 Mile in Oak Park, Benson had assaulted her, Candace Nichols, by striking her with an open hand several times in the face. Officer Pavone could see visible injuries on Nichols' face. Benson stated that nothing had happened on scene and it was a verbal incident only. Benson was later arrested for domestic assault. Benson was previously convicted for domestic assault on 11/5/2018 out of the 45th District Court in Oak Park and convicted for domestic assault second offense on 7/12/2023 out of the 16th Circuit Court of Macomb. I'm asking Your Honor to sign the warrant for domestic violence third offense.
All right, the court finds that the crime was committed. There's probable cause to believe that the man committed it. There will not be any interim bond. Does he have active warrants?
No, he was clear.
Okay.
Oh, yeah. He
Right,
had a DPD warrant. Sorry, he did a DPD warrant. Just traffic.
Okay, is that for the I think, does he have like a retail fraud warrant? Or is that somebody else?
I don't have his paperwork right in front of me.
All right, yeah, my inclination would be to give him some sort of cash bond. What are your thoughts with respect to bond? With the standard no contact?
A higher contact, no contact order.
Okay, so like somewhere in the neighborhood of like 10,000, 10%, 7,500, 10%, something like that.
That works.
Okay, all right. Have yourself a great rest of your weekend.
All right, Your Honor. Thank you. Bye.
Bye. Good morning, sir. Are you Mr. Benson?
How you doing today, sir?
Good, good. I've got your attorney in here. I'll put you two in a breakout room, then we'll get your arraigned.
Yes, sir. So you're gonna talk to the attorney, we'll see if there's there.
Yeah, this were two, here in the breakout room. Okay. Do we have any other non-jailers yet, or just the Oak Park so far?
So far, just the Oak Park.
Okay, thanks. Okay, calling case number 26-21622, people of the state of Michigan versus Andrew Leon Benson. Sir, you're Mr. Benson, correct?
Yes, sir.
Okay, thank you. Ms. Plaster, please put your appearance on the record. How would you like to proceed?
Thank you. Nancy Plaster for purposes of arraignment only on behalf of Mr. Benson. He's going to waive formal reading, stand mute, ask for plea of not guilty, and he is requesting court-appointed counsel.
All right, honorably not guilty for purposes of arraignment. I'll advise Mr. Benson, he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try the matter by judge or jury. He's got the right to remain silent. The silence cannot be used against him. He has the right to be represented by an attorney if he cannot afford one. The court will appoint one for him. He has the right to a preliminary examination within 21 days, where he must, the prosecutor must prove that that there's probable cause that the crime was committed and that it was committed by Mr. Benson. Ms. Plaster, does Mr. Benson qualify for court-appointed attorney services?
He's currently not working, and he has not worked for the last 6 years, and he says he does not receive any public assistance, although he has applied, he's been denied. I believe he'll qualify.
All right, then we'll refer this for assignment of counsel. With regard to bond, in light of the fact that he's got, I think, a bench warrant or two up for him, and it's a felony, my inclination is some sort of low to moderate cash bond, but I'll listen to your argument.
Yes, from my information from Mr. Benson is that his last conviction was from 2023. He may have some traffic outstanding. He's not currently on probation or parole. He denies ever going to prison. He knows to stay away from her. We'd ask for, if not a personal, a lower cash surety bond in this matter.
All right. The court does. Are you sure you want to say something?
Yes, sir.
This is being recorded. This is being recorded, Mr. Benson.
Yes, sir. I'm just asking honor. Like, I know me and my girl, we got into it.
No, we don't want you to talk about the situation, sir. You could say why you can't make a bond or something, but don't talk about.
I ain't got no money. I can't make the money 'cause I ain't have no job and I ain't got it right now, sir. And I'm just asking you to just give me a personal concern. Promise you, I won't have no contact with her. And I will come to the probation. I will come whatever y'all put me on, honor. I'm just asking you, just give me a personal bond today, please, sir.
All right, I appreciate the argument. In reviewing the record, it looks like there's at least one bench warrant out for you, maybe two. I think there might be something out of the 36 on a retail fraud, where there's a bond in the amount of $2,000, something like that. There's some traffic stuff in your background. So in order to ensure your appearance and protect the public, I'm going to set a cash bond, nothing particularly high, but it'll be $7,500 cash surety, 10%. With the condition that you not have any contact with Candace Nichols, that you not harass or intimidate any witness, that you appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or phone number, not possess firearms, other dangerous weapons, refrain from using alcohol, marijuana, or illegal drugs. No new criminal offenses, and you'll be supervised by pretrial services. You must contact within 24 hours of your release. You'll be given their contact information. Next court date's a probable cause conference set for June 15th at 9 a.m. Your exam is set for June 22nd at 9 a.m. Both of those at the Oak Park District Court. All right, you're all set, Mr. Benson. Good luck to you. Thank you, Ms. Plaster.
That's something, honor.
What's that?
So why I gotta pay a bond subject to get released?
Yeah. My bond is $750. If you talk to a bondsman, it'll be much lower than that.
That's like, sir, if I don't have it, what I just go do the time.
You could talk to a bondsman. That'd be between you and I guess your attorney, or you and the people at the jail. So you're all set. Good luck to you.
So I'm gonna let you know. Come on, yours.
All right. Thank you, Ms. Plaster. We'll be talking to you soon.
Okie doke.
All right, sir, state your name.
Mr. Caldwell.
Mr. Caldwell, you're before the court today for your first appearance.
Yes, sir.
I'll appoint the Office of Public Defender to represent you. You've been charged with one count of disorderly conduct. That's a second-degree misdemeanor, punishment of 60 days in the county jail and a $500 fine. I've reviewed the probable cause affidavit. I find there's probable cause for your arrest. Sir, where do you live?
I live 2007, no, sir.
Okay.
Across the bridge.
All right, how long have you lived in Bay County?
Most of my life since 2016.
Is there are you working at this time?
Yeah, I'll start my job tomorrow. Well, I did start today. I mean, today's Friday, right? Okay.
Today's Saturday. Where were you going to start?
Well, I was supposed to start yesterday, but I went to jail.
Okay. Is there a prior record on Mr. Caldwell?
She had a VOP last year, disorderly intox. I'm not showing him on probation at this time anymore, but trespass, resisting without, 2 FTAs, 1 in 25, 1 in 23, couple more disorderly intoxes in 22, failure to register as a felon, 21 and 17. In Georgia, he's got resisting without trespass, 24, trespass 20, and DV battery 19.
All right, I'm gonna set a $250 bond. He'll be able to contact family and friends in order to make his bond. Good luck.
Yes, sir. The court date?
The court date will be, I'm sorry, June 10th at 8:30.
Yes, sir. All right. All right, you step out.
I'm just ready to go.
Yes, sir. Step on the edge. Say your name for the judge, please.
Courtney Johnson.
Mr. Johnson, you're before the court today for your first appearance. You're not asking for the public defender, so I'm not going to appoint him today. You've been charged with one count of possession of paraphernalia. That's a first degree misdemeanor, punishment 1 year in the county jail and $1,000 fine. Possession of marijuana less than 20 grams, first degree misdemeanor, punishment 1 year in the county jail and $1,000 fine. And driving while licensed suspended or revoked. That's a traffic misdemeanor, punishment 60 days in the county jail and a $500 fine. You've also got an outstanding capious for failure to appear. And Judge Smith has set a $2,500 bond on that. I'm gonna leave that bond as it is. Ms. Johnson, where do you live? And I'm gonna find probable cause for the other charges. Where do you live at, ma'am?
Panama City.
All right. And are you working?
Yes, sir.
Where do you work?
KFC.
Okay. And does Ms. Johnson have a prior record?
No, sir. That FTA came from an NTA that she didn't appear for court for, apparently. That's it.
Okay. All right. What I'm going to do then is based on the failure to appear, I'm going to set a $500 bond on each of the other misdemeanors for a total of $1,500. You've got the $2,500 already set. You'll be subject to random UAs based on the charges. Your next court date's June 10th at 8:30. Good luck.
Next. Step on the edge. State your name.
I'm sorry, I hear you.
Sarah Jones.
Ms. Jenkins, you're before the court today for your first appearance. I'm going to appoint the Office of Public Defender to represent you. You've been charged with one count of driving under the influence. That's a traffic misdemeanor. If it's your first offense, it's punishment 6 months in the county jail and a $500 fine. You also have one count of resisting officer without violence. That's a first degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. I reviewed the Florida DUI uniform traffic citation, as well as the probable cause affidavit. I find there's probable cause for your arrest. Ms. Jenkins, where do you live?
Holmes County.
How long have you lived in Holmes County?
22 years.
Are you working?
Not. I'm supposed to be starting work today.
Okay.
Is that the new I start my job on Monday? I was supposed to be starting work today, but I got arrested. I was supposed to start work yesterday, but I got arrested. What? Is that really the thing? Everybody gets arrested the day they're supposed to start their job. That is just crap timing.
Where were you going to start today?
Shipwreck Island, Water Park.
All right. Is there a prior record on Ms. Jenkins?
No, sir.
All right. Ms. Jenkins, I'm going to recommend you to the pretrial release program. That'll get you out of jail and have to put up a bond. There's some standard conditions you'll have to abide by. You're not possessed or consuming the alcoholic beverages. You'll be subject to random breathalyzers and drug test at the request of the pretrial release officer of the court. Your next court date is July 10th at 8:30. Good luck.
Next. Say your name for the judge, please.
Emily Lily.
Ms. Williams, you're before the court today for your first appearance.
This is Miss Lily, sir.
Huh?
This is Miss Lily, sir. Number 4.
Oh, Miss Lily, I'm sorry. I did that pulled out. All right, Ms. Lily, you're before the court today for your first appearance. You're also going to have a shelter hearing later on this morning when I can get that Zoom room where I can get into it. You've been charged with one count of child neglect without great bodily harm. That's a 3rd degree felony, punishable with 5 years in the Florida Department of Corrections and a $5,000 fine. I reviewed the probable cause affidavit. I find there's probable cause for your arrest. Ms. Lily, where do you live?
I live on the property with my grandparents.
I'm sorry, where?
I live on the property next to my grandparents.
Okay. And are you working?
I've been looking for employment.
All right. And is there a prior record on Ms. Lily?
This is an added charge. She was first appeared already on the others, I believe. And she's got a child abuse in 25 in December. She's also out on an NTA for petty theft.
And Your Honor?
Davina, I didn't want to discourage you from asking. I just didn't quite hear what you were asking me.
Oh, that was about another matter. In this one, I just wanted to advocate for a substantial bond.
Okay. All right. I am going to set a $10,000 bond. Right now, you'd have no contact in the criminal case with the alleged victim of the case. Now, in the dependency court, you'll be allowed supervised contact, but you'll have no contact until the criminal judge releases that. Do you understand?
No.
Okay, that means you'll have no contact with your child until the criminal court lifts that no contact order.
Okay.
Now, in the dependency court, you'll have supervised, but you won't be able to visit until the judge allows it.
Okay.
The next court date on the child neglect will be July 16th at 9 o'clock. Good luck. And I'll see you again later on this morning.
On the X, state your name for the judge, please.
Ward.
Ms. Ward, you're before the court today for your first appearance. I'm going to appoint the Office of Public Defender to represent you. You've been arrested on 2 outstanding warrants. One, child abuse, that's a 3rd-degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. 1 count of disorderly conduct, that's a 2nd-degree misdemeanor, punishment to 60 days in the county jail and a $500 fine. You also have a new charge of no valid driver's license. That's a 1st-degree misdemeanor, punishment to 60 days in the county jail and a $500 fine. I reviewed that uniform traffic citation, find there's probable cause for your arrest. Ms. Ward, where do you live?
717 Rock Little Road.
Okay, and how long have you lived in Bay County?
My whole life.
Are you working?
No.
Is there a prior record on Ms. Ward?
She's on probation for battery with Judge Dyer. That's it.
What, you have a case number on that?
25 3175 mm.
On the cruel, on the child abuse, I'm gonna set a $5,000 bond. On the affray, a $500 bond. On the no valid driver's license, a $500 bond. I'm gonna issue a warrant based on the new charges, alleging she violated, and I'm gonna issue a warrant for a violation of probation. She'll be held without bond on that. On the new charges, her next court date's July 9th at 9 o'clock. Good luck to you, man.
Next. On the X. State your name, please.
Ms. Clyde, you're before the court today for your first appearance. And appoint the Office of Public Defender to represent you. Got new charges of possession of methamphetamine. This is a 3rd-degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. And possession of drug paraphernalia, which is a 1st-degree misdemeanor, punishment to 1 year in the county jail and a $1,000 fine. I've reviewed that probable cause. I find a probable cause for that arrest. You've also got a probable cause affidavit, possession of
Oh boy. And she held it together in her hearing for, a little while. Gets out of earshot of the judge, so she thinks. And she starts screaming.
possession of fentanyl, possession of methamphetamine, and possession of drug paraphernalia. I find probable cause for that. You've got an outstanding warrant for petty theft. It doesn't say what. I'm on first period as a 2nd-degree misdemeanor. Ms. Clyde, where do you live?
I live in Bay County.
How long have you lived in Bay County?
I've been here 2 years.
All right. Where do you come from?
I came from Jacksonville, Georgia.
And are you able to work?
Yes, sir, I do work.
Where do you work?
I've been a surgical assistant 16 years, and right now I've got a broken ankle, so I've been also selling peptides. It's a new up-and-coming type of vitamin drink for a lot of different things.
There's a prior record on Ms. Clyde.
She got an FTA in March. And locally and in Georgia, she's got violation of protection order 24 and 19, maintaining a disorderly house. That's it.
Based on failure to appear, I'm going to set a $5,000 bond on each of the 3rd-degree felonies, possession of the controlled substance. I'm going to set $1,000 on each of the paraphernalias. $500 on the petty theft. Your next court date's June 25th at 9 o'clock. You'll be subject to random UAs based on that possession allegations. Good luck.
Give us 1 minute, Your Honor.
Yes, sir.
Did you order a no contact from Ms. Ward? I can't remember.
I don't think you mentioned it, Judge. I think you held it out on her.
I did. I did.
You did.
On
Yes, sir.
Ms. Ward, I did order a no contact.
Yep.
Mr. Moore, you're before the court today for your first appearance. Based on your financial affidavit, I cannot appoint the public defender. You've been charged with 1 count of driving while license suspend or revoke. It's got second conviction or subsequent. Are they charging with a felony or a misdemeanor? On the paperwork, on the first appearance they have is a county court. But wouldn't that be a second or subsequent? Is that still just a first degree misdemeanor? Okay.
It's a first degree misdemeanor.
That's punishment for 1 year in the county jail and a $1,000 fine. I reviewed the Florida Uniform Traffic Citation and find probable cause for your arrest. Mr. Moore, where do you live? Where do you live at, sir?
1610 Friendship.
Is that Bay County?
Yes, sir.
How long have you lived in Bay County?
Sorry?
How long have you lived in Bay County?
4 years.
Are you working?
Yes, sir.
You work.
Burger King.
Is there a prior record on Mr. Moore?
He's on probation for battery DV with Dyer. It's a felony drop down that occurred in July of last year. That was a tender 911 false imprisonment ×2 DV battery and criminal mischief. 24, he's got false name to Leo, resisting without, VOP, 22 DUI, pretrial release violation, and elsewhere in Florida, he's got a FTA last year. 24 habitual. Yes, sir.
All right. On the new charge, I'm going to set a $1,000 bond. I am going to issue a warrant allegedly violated the terms and conditions of his probation. I'm going to hold him without bond on that. The new case will be June 10th at 8:30.
Yes, sir.
What's that
You
case
got the case?
That's that
26 315 mm.
315.
Yes, sir.
All right. Thank you, sir. That'll
What'd you
conclude.
say? What'd you say the court date was?
June 10th at 8:30.
Yes, sir. You step out. State your name for the judge, please.
My name is Christopher Goodwin, Virginia.
Mr. Goodwin, you're before the court today on a first appearance. You've been arrested on an outstanding warrant signed by Judge Smith. Alleging 1 count of aggravated assault with a deadly weapon. That's a third-degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine, and 1 count of aggravated battery using a deadly weapon. That's a second-degree felony, punishment to 15 years in the Florida Department of Corrections and a $10,000 fine. Judge Smith found probable cause. Mr. Goodwin, where do you live at?
I live in Southport, Florida. I've been there all my life. I'm a resident here. Been here all my life, sir. It was just a boating accident, man. It wasn't nothing I meant to do.
Okay. You don't need to talk about your case. See, if I hadn't, I'm gonna appoint the Office of Public Defender. Mr. Phillips, you got any information about the case?
No, not in response to what he said. I don't have any.
What's the prior? Is there a prior record on Mr. Goodwin?
Yeah, this is an added charge. He's got aggravated battery he was charged with, an assault that he's currently in custody for as well. He's got a criminal mischief under 223, couple of VOPs, older VOPs. His history goes back to 2000, stalkings and batteries and whatnot.
Well, I'm gonna set a $5,000 bond on the aggravated assault and $15,000 bond on the aggravated battery. No contact with the alleged victim in the case. The next court date, July 9th at 9 o'clock.
Go. Step out, please. Next. Step on the X. Say your name for the judge, please.
Julio Cesar Espinoza.
Mr. Espinoza, you're before the court today for your first appearance. I am going to appoint the Office of Public Defender. You've been arrested on an outstanding warrant. Burglary of a dwelling. That's a second-degree felony, punishment to 15 years in the Florida Department of Corrections and a $10,000 fine. And theft of utility services, which is a third-degree felony, punishable for 5 years in Florida Department of Corrections, and a $5,000 fine. Jeff Cope found probable cause and issued the warrants. Mr. Espinoza, where do you live?
Destin, Florida.
Where?
Destin, Florida.
How long have you lived in Destin, Florida?
5 years.
And are you working?
Yes, sir.
And is there a prior record on Mr. Espinoza?
Elsewhere in Florida, he's got an FTA this year, possession of burglary tools with intent 26, paraphernalia, controlled substance, theft of utilities ×2, and another burglary. California, he's got invasion of privacy 17, 19 DV battery, and harassing phone calls.
All right, I'm going to set a $15,000 bond on the burglary, $5,000 on the theft. The next court date is June 25th at 9 o'clock. Good luck to you, sir.
Thank you.
Your Honor, number 21 is a little bit unstable. He decided not to come down this morning.
Okay, do you want to put him on the docket for tomorrow, or you just want me to set bonds?
I don't know if it's going to be any different tomorrow, but it's up to
Your
you.
Honor, we have a request on that too when you get a
Okay,
second.
go ahead with your request.
I think Shavina, did you want to jump in? The sheriff's office, there was some
Yes.
potential exposure to blood. Well, let me let Shavina explain.
Yes, Your Honor, apparently, a couple of our deputies was exposed to his blood and he wouldn't disclose any, STDs or anything like that. And so they were requesting, that he have his blood tested. I don't know if this is the time that we do that or if the state needed to file a motion for that.
I don't know either on it, so an abundance of caution, we'll just let you work with the state on that.
Okay, thank you, Your Honor.
What I'm gonna do is I'm gonna set. I found probable cause on all of them. On the 3 counts of resisting officer violence will be $5,000 a piece. On the battery, third-degree felony will be $5,000. Obstructing the police by means of protection of communication is going to be $5,000. The aggravated battery is going to be $15,000. And the resisting officer without violence will be $1,000.
I think there should be some kind of special charge or at minimum special place in hell for someone who refuses to disclose bloodborne diseases after officers have been exposed to their blood. That's just a cruel, cruel punishment and unnecessarily to the officers. For 6 months, they can't have intimate contact with their spouses without protection because they have to go through an initial screening, a screening after 3 months, and a screening after 6 months to make sure that they don't expose their spouse to something if they were exposed to it. Like, I'm sorry, but no one deserves that kind of mental anguish. It's no different than what a victim who is raped has to go through mentally. When you question every day, did they give me something? Absolutely disgusting.
His next court date is July 9th at 9 o'clock. And if I fail to do so, I'll appoint the Office of Public Defender to represent him.
No contact, sir.
No it's all, yeah, no contact. Yeah, no contact.
Yes, sir.
And that will conclude my business. Thank you, Your Honor. Thanks, Ryan.
You speak. State your name. Yeah. 20.
Oh, good. All right, who is this? Mr. Latour, you're before the court for your first appearance. I'm going to appoint the Office of Public Defender to represent you. You've been charged with one count of trafficking and methamphetamine.
Last guy.
First degree felony, plus 30 years in the Florida Department of Corrections, possession of controlled substance. That's a second degree, and a third degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. Tampering with evidence, that's a third degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. Possession of marijuana less than 20, which is a first degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. And possession of drug paraphernalia, which is a first degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I find there's probable cause for your arrest. Sir, where do you live?
I live in Sanford. Sanford, Panama City. I just moved from Sanford.
How long have you lived in Bay County?
Like 2.5 months.
Okay. And where did you come from?
I came from Seminole County, I'm sorry.
Okay. And are you working?
Yes.
Where do you work?
I work at 2 different places. I work at Dee's Hangout and Lake Town.
All right, is there a prior record on Mr. Latour?
Locally, he's got some older stuff from the early 2000s, but elsewhere in Florida, he's got DVSR last year, paraphernalia, 23 impersonating an individual, credit card fraud, shoplifting, BOP, possession of meth 22, BOP times 2, 21 paraphernalia times 2, possession of meth habitual, DVSR habitual, possession of meth times 2, and then 16 of BOP. That's all I'm showing.
Sir, based on your prior record, I'm going to set a $75,000 bond on the trafficking, 5 on the possession of a controlled substance, 5 on the tampering, 1,000 on the possession of marijuana, 1,000 on the paraphernalia. You're not to possess any illegal substance. You'll be subject to testing for that. Your next court date is June 25th at 9 o'clock. Good luck.
87,000. 87,000. Next. Step on the edge. State your name for the judge, please.
Mr. Brady, you're before the court today for your first appearance. You've been arrested on 1 count of trafficking and methamphetamine. That's a first degree felony, punishment 30 years in the Florida Department of Corrections and a $1,000 fine. You've been arrested on the outstanding warrant alleging felony battery. That's a third degree felony, punishment with 5 years in the Florida Department of Corrections and a $5,000 fine. 1 count of petty. You've been also arrested on an outstanding warrant alleging petty theft. That's a second degree misdemeanor, punishment with 60 days in the county jail and a $5,000 fine. You've also got 1 count of no motor vehicle registration, traffic misdemeanor, punishment with 60 days in the county jail. Driving while license suspended or revoked. If it's your first offense, that's punishment with 60 days. I reviewed the probable cause affidavit. I reviewed the uniform traffic citation. Also, you were arrested on warrants on the battery and the theft. So the committee magistrate found probable cause on that. Mr. Brady, where do you live?
I live in Bay County, sir.
How long have you lived in Bay County?
Probably 15, 20 years now, I guess, probably.
Are you working?
No, sir, I'm a disabled war vet.
Okay.
100% second to the WPA.
Is there a prior record on Mr. Brady?
Locally, he's got 3 FTAs and 23, an FTA and 20, possession of meth, 20. He's also got burglary dwelling grand theft, 19 grand theft, 18 grand theft, burglary of a dwelling again, and 18 VOP for DV battery, 16 DV battery, older DV battery, and 15. He's also got elsewhere in Florida paraphernalia and VOP and controlled substance of 19. That's all I'm
setting $75,000 bond on the trafficking and methamphetamine, 5,000 on the felony battery, 1,000 on the theft, 1,000 on the possession of paraphernalia, 1,000 on the driving while license suspended or revoked, and 1,000 on the no motor vehicle registration. His next court date is July 16th at 9 o'clock, sir. Based on those charges, you're subject to random UAs on the direction of the court, and you're to have no contact with the alleged victim in the battery. Good luck.
Let's step out. I'll get your paperwork to you. Next.
I was typing. Oh, yeah. I couldn't mentally handle the trauma of it. I remember the fear from when I was essayed. And it was a year of panic. Like even though the tests came back negative, I wasn't calmed any. I still always wondered, was there something that didn't get tested for or didn't, get seen or, yeah. And I know that's silly to think that, but when you've been exposed to something that you had no control over by someone that you didn't know, that fear is real. And it's not something that anything can fix, Your brain's going to wander and go wherever it's going to go. So, and it doesn't go away. It even though I was 18, I'm 43 now. I mean, that was a long time ago. And I still at times think about it like, yeah. Oh, I was worried a couple of times because of my own behaviors too, but that pales in comparison to the worry that I had when I had no control. All right, guys. Thank you. Thank you for coming and hanging out with me. I had fun showing you fresh new Sunday content, all from Sunday. Usually I don't do the arraignments. Usually on weekends I go to the archive drive and find something. But I just felt like when I saw Magistrate Braley went live, and I was like, oh, let's watch this. And it turned out to be really great. And then I was like, oh, well, let's check out what Brantley did today. And there was the two or three people that started their job the day before the day of getting arrested. And I was like, oh, I have to throw that in there. I have to put that in. And then there was the panhandler who was previously convicted of 2 homicides and multiple aggravated batteries and assaults. And I'm like, yeah, that's why I don't stop the car. So fresh, you should check out their Jordans. I'll be expecting that package in the mail, Donald Westerdale. Be safe, be well, sleep sweet, and much love.